Get ready for the dictation. Start. As far as the relationship of the licensor or licensee is concerned, he submits that the respondent has failed to produce any evidence in support of his submission that the construction of the property had been conducted by the respondent. In fact, relying upon the suggestion given to the PW1, he submits that the construction of the property was made when the respondent, as per his own case, was in the village. I have considered the submissions made by the learned counsel for the appellants, however, find no merit in the same. It is to be noted that the appellants oblique plaintiffs themselves did not came to the witness box in support of their claim. The London Appellate Court has found this to be one of the main ground for disbelieving the case of the appellants oblique plaintiffs and mere statement of PW1 in his examination in chief to state that these documents were executed in his presence, in my opinion, would not suffice or negate the effect of the plaintiffs not entering the witness box to prove their case. The Supreme Court, in judgment dated 1/10/2019, passed in Civil Appeal numbers 286970/2010 titled Mohinder Kaur versus Sant Paul Singh, has held as under. In Janki Vasudev Supra, it was held that a power of attorney holder who has acted in pursuance of the said power may dispose on behalf of the principal in respect of such acts, but cannot dispose for the principal for the acts done by the principal and not by the power of attorney holder. Likewise, the power of attorney holder cannot dispose for the principal in respect of matters of which the principal alone can have personal knowledge and in respect of which the principal is entitled to be cross-examined. In our opinion, the failure of the respondent to appear in the witness box can well be considered to raise an adverse presumption against him, as further observed therein as follows. Apart from what has been stated, this court in the case of Vidyadhar versus Manika Rao observed at SCC PP 58384 para 17 that where a party to the suit does not appear in the witness box and states his own case on oath and does not offer himself to be cross-examined by the other side, a presumption would arise that the case set up by him is not correct. Even otherwise, the question of providing all these documents, specifically in light of the fact that the appellants oblique plaintiffs or the attesting witnesses of such documents had not entered the witness box, the documents did not bear the signatures of the beneficiaries, the documents are unregistered, and even otherwise the relationship between the parties are matters of appreciation of evidence and of arriving at a probability, which is the standard to be applied in a civil case. The court, in exercise of its jurisdiction under section 100 of the Code of Civil Procedure 1908, cannot examine the case by reappreciating the evidence. I further find no substantial question of law having been made for interfering in the impugned judgment. In S. Subramanian versus S. Ramasamy and others, MANU/SC/0650/2019, the Supreme Court, in relation to the powers of the court under Section 100 of the Code of Civil Procedure 1908, has held as under. Stop.